morning. This is call number 2020-79453 in the interest of Kayla, Autumn, and Camden Covey. All
Morning, Judge.
parties and witnesses, please raise your right hands to be sworn. Unmute yourself, please. Unmute yourself, Mr. Romero.
Right.
You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, sir. Please state your name and your relationship to the children.
George M. Romero. I'm the father of Autumn Covey and Canham Covey, and Kayla is not mine, but I fathered her for the last 4.5 years.
All right. Counsel, your name and who you represent.
John Lemos. I represent Jorge Romero, the petitioner.
All right. Court will note that the mother, custodial parent, Natalie Covey, is not present. She was personally served at 1:40 p.m. on 22nd of July 2021 at 1210 Fry Road in Houston, Harris County, Texas. That was at 8:16 p.m. Sorry, on the 23rd of July 2021. And she's not present. She's not filed an answer. Is that correct, Ms. Williams?
Yes, Your Honor, that's correct.
All right, and representing the state?
Jarquita Williams for the state, Your Honor.
All right, we've got a petition to establish parent-child relationship. What are we doing today?
Well, today, Your Honor, this isn't the OAG setting. This is actually the opposing counsel setting, and they're asking to transfer the case to district court. However, there's an issue about whether or not Ms. Covey has received appropriate notice of today's Zoom hearing.
Well, I see that she has filed a request for court hearing, so there has been an answer filed.
Let's see here, 1 second, Your
Yeah,
Honor.
she did file that. You're correct, Judge. I do recall that now. And if I
Oh,
may,
sorry, Your
Judge,
Honor.
yeah, we showed up on, I had filed, just to kind of bring you up to speed on the history of the case. I had filed a counter petition in the case, kind of like a cross claim, so to speak, where I had raised all the children's issues because Mr. Jorge Romero wants to fight for primary. And when I did that, for some reason, the district clerk funneled this case from the 311 to the 312. So I set the case for a hearing in the 312 on 8/25. When I showed up in front of Judge Bachman, she advised the Minerva Ramirez, myself, and Natalie Covey that all we would need to do is set a hearing with the 4D court, kind of like an administrative deal, so we could get the case transferred to the 312. The OAG on that date was unopposed, Minerva Ramirez. I still think they're unopposed. It's just a matter of getting this case transferred to the 312 so we can have this hearing. And the hearing is actually set for tomorrow at 1:30. I have emailed back and forth with Natalie Covey in open court. She provided this email to the judge as her form of where she wanted to be served. So this is the email I've been using to communicate with her. I've talked to her on the phone several times. And this is where she wants everything served. This is what she provided the court.
All right, let me look at this. August 25th, Judge Boffin entered notes, temporary orders. Petitioner appeared in person with counsel. Respondent appeared in person pro se. OAG appeared via Zoom. Case is currently before 4D court and has not yet been transferred. Respondent made her appearance. Temporary order reset for in-person hearing.
Yeah, we were all in agreement that day. It was a matter of just administratively getting it done.
Correct, Your Honor. And the OAG, we have a hearing also set for this matter for November 5th. And so Mr. Lemus, he set the matter for today. So
it's actually October 5th, I think.
October 5th. Yes, you're correct. Thank you, Mr. Lemus.
No problem at all.
So Mr. Lemos, you're saying that the mother was in agreement. Is that correct?
Yes, we were all in agreement that day.
To transfer it.
Yes, it was just a matter of administratively getting it done. Judge Bachman sort of explained the process, and then I followed up with Minerva thereafter in several emails, and she kind of told me how I had to set it with the 4D court. This is not anything I've ever done before, and when I filed into the case, for some reason it ended up in the 312. It's not anything I even asked for. I don't know why it ended up in the 312, but it did.
Well, okay, so
That is the presiding court.
this is being transferred to the 312th?
Yeah, for some reason, when I filed the counter petition, I've communicated with the 311th, and they're like, sir, we can't do anything because the case is in the 312th. So then when I talked to Minerva, she's like, yes, but the 4D case isn't because of the standing order. So just file an objection to the 4D court and ask for a transfer to the 312. So then everything can be in the 312. That's exactly how she explained it to me.
All right, and you have a hearing set for tomorrow?
Tomorrow at 1:30. And I feel like it's pretty time sensitive because Mr. Romero has a child and she has two of the children. And I think they're both waiting on orders before they do anything with this child. They both haven't seen, respectively, the other children in the other's possession. And we're trying to just get some orders in place and some delineation from Judge Bachman.
So it's set for hearing September 14th.
Tomorrow at 1:30. And we were all
And
signed,
she
we all
knows
signed off
about
that we'd be there.
Okay, hold
We all
on.
signed an agreement that we would be there on the 14th at 1:30 as well. Again, that was also an agreement. So we're all expected to be there at 1:30 tomorrow.
All right, I'm going to rely on Mr. Lima's testimony that in fact mother is in agreement to have the case transferred, and I'm transferring it to the 312 District Court, and the case is set in that court at 1:30 p.m. for hearing in that court at 1:30 p.m. All right, anything else?
All right.
No, that'll do it,
No, Your
Judge.
Honor.
Thank you.
Okay, thank you.
Thank you, Your Honor. You all are free to go. Thank you.
All right, no, thank you. Thank you.
They want to do what? A Band-Aid order?
Good morning, Judge.
Good morning.
Good morning.
Good morning. Jones.
Good morning, Your Honor.
Where is the AG?
I don't know.
We want to admit her, right?
Here she is, Your Honor. I see her.
Okay. There she is.
Good morning, Your Honor.
Good morning. Hold on just a second. All right, this is cause number 2021-29108 in the interest of Kaylee and Kevin Walker. All parties, witnesses, please raise your right hands to be sworn. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
I agree.
All right, ma'am, please state your name and your relationship to these children.
Oh, Kelsey Trahan, the mother of the kids.
All right, and representing Ms. Strahan?
It's Attorney Shonda Jones, Your Honor. I'm here.
All right, sir, your name and your relationship to the children.
Kevin Walker, and I'm the father to the children.
All right, and representing the father.
Aaron Putman for Mr. Walker.
And for the state.
Angela Jeffries for the Office of the Attorney General.
And what are we doing today, Ms. Jeffers?
Yes, Your Honor. I believe Attorney Jones has filed an objection to the associate judge. So at this time, they're requesting that the case be referred to district with mediation order. The parties have also reached an agreement regarding a Band-Aid order, pending temp order. So they would like to read the Band-Aid order into the record, Your Honor, before the case is referred to district court.
Okay, let's do that then. This is an agreed order.
Yes, Your Honor.
Yes, sir.
Okay.
And Attorney Putman will read that into the record, Your Honor.
All right.
Ready when you are, Judge.
This is an agreed temporary order, correct?
That's
Band-Aid
correct.
order, Your Honor.
All right, let's proceed.
The parties agreed to a joint motion and order for custody evaluation based on a sliding scale to be conducted by the Domestic Relations Office of Harris County. Child support will be set at $535 a month beginning October 1, 2021. Dad to cover health and medical with his private insurance, and that also begins October 1, 2021. The parties have also agreed to a modified possession and access schedule that begins Saturday at 8 a.m. after the first, third, and fifth Friday. Parties agreed to exchange the children at the Saturday at 8 a.m. at the McDonald's located on 4503 Garth Road in Baytown, Texas, 77521. Mr. Walker will surrender the children that following Monday at 6:45 a.m. at at Imagine Me Daycare on 1310 Garth Road, zip code 77520. The parties have also agreed to utilize the Talking Parents application and have agreed to a joint and mutual injunction against consumption or possession of illegal drugs around the children. And I'll call my first witness.
Yes, ma'am.
Oh, I'm sorry, Ms. Jones, I think.
I'm sorry, Attorney Putman. I was also hoping we could just do standard injunctions also, ma'am, as it relates to, the parties as it regards to children, as standard as they are pled.
I don't think, was your paramour provision in the standard injunction?
Well, except for, if you want, we can at this point not include that because I don't think that's standard.
Okay, well, standard injunctions as well, Judge. I'm fine with that. Okay, and I call my first witness, Kevin Walker.
All right.
Mr. Walker, did you hear the terms of the Band-Aid or agreed interim temporary order?
Yes, ma'am.
And it is your agreement and your understanding that these terms as far as child support, medical support are to begin October 1st, 2021. Is that correct?
Yes, ma'am.
And you've had a discussion with Attorney Jeffries and I regarding direct payments. Is that correct?
Yes, ma'am.
Okay. And are you also asking this court to issue a income withholding order so you won't have to do those direct payments to Ms. Trahan?
Yes, ma'am.
Okay, but you do understand that more than likely income withholding order will not be in effect by October 1 and you are to pay her directly. Is that correct?
Yes, ma'am.
Okay, and you stated that you would be paying by check for that first payment?
Yes, ma'am.
Okay. And you do understand that instead of taking the children to school on that Monday, you will be surrendering them at 6:45 a.m. by 6:45 a.m. at Imagine Me Daycare, correct?
Yes, ma'am.
Okay, and you are to utilize the Talking Parents application to communicate with mom regarding the children, correct?
Yes, ma'am.
Okay, and you do understand that there is a joint and mutual injunction against the consumption or possession of illegal drugs around the children?
Yes, ma'am.
Okay, I pass the witness.
Any questions, Ms. Jones? Okay.
No, sir.
All right. Anything further, Ms. Putman?
Yes, I'd like to call Ms. Trahan.
All right.
Yes, ma'am.
Ms. Trahan, you heard the testimony of Mr. Walker, is that correct?
That's correct.
And is that your understanding of the agreement as well?
Yes, ma'am.
And no one forced you or promised you anything to enter into this agreement?
I mean,
No.
Okay. And just because we're about 20 days shy of October 1st, you do understand that dad will be making that direct payment to you for child support, okay?
Yes, ma'am.
And dad is to cover the children under his private health insurance. You understand that, correct?
Yes, ma'am.
And you do understand that that injunction against consumption or possession of illegal drugs is joint and mutual for both parties.
Yes, ma'am.
Okay, I pass the witness at this time.
Any questions for Ms.
No
Jones?
questions, Your Honor. No, sir.
Ms. Jeffries, any questions of the mother or father?
No, Your Honor.
All right, then the case is transferred to the 245th District Court and DRO mediation is ordered. Anything further?
No, sir.
No, Judge.
All
Oh,
right, thank
Your
you.
Honor, Your Honor, despite the fact that DRO mediation is ordered, that doesn't exempt, I mean, that doesn't prevent us from getting our own private mediator, correct?
Well, you'll have to talk to the 245th. I'm sure that'll be fine, but they always request DRO mediation unless you all have somebody that you're already in agreement with that's going to do the mediation.
And I'm fine with working with you on that, Ms. Jones, especially because
Okay.
we have some orders in place right now to allow us to get into mediation.
Okay, so then there will be private mediation. Ms. Jones?
Either or, Judge.
Yes,
We definitely wanted some kind of mediation, but we have some Band-Aid orders. So just the order to mediation should
All right,
suffice.
I'm just going to order mediation and
Thank
not
you.
indicate
Okay,
where.
thank you,
but
Your Honor.
Normally, they want DRO, but or if you already have a private or you can't get a private, that's fine with them. Okay,
Thank you, Your Honor.
Okay.
thank you.
Thank you, Judge Longoria. Have a good day.
Thank you.
You too. Thank you.
Yes, sir. Bye-bye.
Attorney Jones and Attorney Putman, I'm still gonna do the